welcome Professor Gillian Triggs, who is Emeritus Professor of Law and President of the Australian Human Rights Commission since 2012. She's been Dean of the Faculty of Law at the University of Sydney and Challis Professor of International Law. And before then, she was the Director of the British Institute of International and Comparative Law from 2005 to 7. Her work in the field of law as an advocate, wearing numerous hats, has spanned an impressive lifespan of 50 years. And I don't think a one-hour seminar would do us enough in terms of wanting to learn as much as we can from her about human rights advocacy and how we can progress on our individual journeys on working towards achieving greater protection for minorities. But nonetheless, given that she's in Hong Kong for such a short time, we're really very, very pleased to be able to have you here before your lecture later tonight, where she will be speaking about the Charlie Hebdo issue and the impact it has had on the discussions relating to free speech in the region. Professor Triggs and some of our colleagues at the faculty have had the opportunity to brief her on Hong Kong's situation over the past hour during lunch. So unfortunately, she sort of had to endure a crash course on the sort of situation of Hong Kong. And so I won't delve too much into it, but just by way of background, I'd like to reiterate that obviously, as many of you know, we work in a context where Hong Kong is a party to numerous international law treaties, including CEDAW, CERD, the CRPD, and the CRC. And in light of that, we do regularly report to the UN treaty bodies, which is a process that the government is engaged with, as are many of you, wearing your hats at the NGOs that you work for. We have an Equal Opportunities Commission in Hong Kong, which has remit over our 4 anti-discrimination laws, which cover sex discrimination, disability discrimination, family status discrimination, and race discrimination. However, the EOC does not have the mandate over the other human rights that are part of Hong Kong's laws. And as many of you would know, the Hong Kong Basic Law entrenches the treaty provisions through Article 39 of the Basic Law. By treaty provisions, I'm referring specifically to the ICCPR and the ICESCR. And so in light of that, the Commission has a number of powers to investigate, to help parties conciliate, which is its primary objective by way of the individual complaints mechanism. And it also conducts research and has a policy arm, which has been very active in recent years. On occasion, the EOC has intervened in court on behalf of certain parties, and it has gone to court against the government on a couple of issues involving discrimination. So we have that body. But of course, as we all also know, the EOC is not a body that is compliant with the Paris Principles. So in that sense, it's not strictly what you would think of in terms of an independent human rights institution, which has the purview of monitoring the government across its human rights obligations. With that background, Marco and I are just going to share sort of developments relating to the minority, the situation of 2 distinct groups of minorities, that is ethnic minorities and sexual minorities, simply to sort of use them or their situation as the lens through which we can examine how we can strategize or use existing frameworks and approaches to improve progress towards better human rights protection for other minority groups across the board in Hong Kong, of whom we have many. And to that end, I also think it would be helpful for Professor Triggs to know that in the room we have members of the EOC, we have representatives from NGOs, including the Hong Kong Human Rights Monitor, Hong Kong Unison, which works with ethnic minorities in Hong Kong, Pathfinders, who works with migrant workers' children. We also have, or are supposed to have, the Honorable Fernando Cheung, but he's probably on his way. He's a Legislative Council member who's been advocating for the rights of victims of domestic violence as well as children and other persons with disabilities. We have Billy Leung from Pink Alliance, and we also, I believe, have friends from the Queer Straight Alliance. I think Jeffrey should be here or coming here soon. So anyway, there's a number of us in the room who are very, very keen to learn from you, Professor Triggs. On ethnic minorities in Hong Kong, the situation, sadly, is that although we have a race discrimination ordinance, it is one that doesn't compare well with the other 3 anti-discrimination ordinances, and that it has numerous exemptions, and I won't get into all of them. Suffice it to say that it actually exempts government functions and powers from the remit of the ordinance. And that leaves the ordinance sort of applicable to areas such as the provision of goods and services, and employment and the like. So those are the areas of discrimination that are dealt with under the ordinance. The situation has been particularly difficult for ethnic minority children in that they have been going through an education system which has been branded as sort of Hong Kong's racially segregated system, mirroring that which we saw in the US in the 50s. And so to that end, we have an overconcentration of ethnic minority children in about 22 schools across the territory. On an official basis, the policy for designated schooling has been disbanded. However, we still see children going to the same schools, and there are a number of reasons for that, but we won't get into that. But by and large, what it means is that ethnic minority children don't have equal access to quality education. And as a result, they're not able to get into higher education institutions. They don't fare well because they can't compete on an equal footing with the local Chinese counterparts in the job market. There is something called the Panadol therapy in the healthcare system where, because of a lack of accessible service in terms of language to the health sector, a lot of ethnic minorities are prescribed Panadol to fix any and whatever problem they go to the healthcare system with. This is something that the refugee population faces as well in Hong Kong. So there's a whole host of problems. And in terms of the advocacy work, there has been a tremendous, I think, effort in seeking to lobby whoever possible, including the government bodies concerned, the UN treaty bodies, and we've secured relevant concluding observations to drive the government to perhaps do more. But unfortunately, these efforts haven't quite yielded the kind of outcomes that these communities have been looking forward to. Since 2009, which is when the RDO came into effect, we've only had one case on discrimination on the grounds of race that has been brought against the police by a young man from the Indian community. The judgment is still pending, so we don't know how that turns, but there has been an issue as to whether police powers are even covered by the ordinance in light of the exemption I mentioned. So as we wait, we very much are eager to learn more about what approaches and strategies you might recommend when you face resistance and inertia on the part of the government, even when you've got leading international sort of opinion that this is clearly an undesirable situation. And it's contributing to difficulties in terms of equal protection in other areas of generations of children who are affected by this. And more importantly, when you have a public who doesn't necessarily believe that certain minorities should have equal rights like themselves, how do you sort of tackle that? I'm going to leave it there on the race question, and I'd like to invite Marco perhaps to give us a little bit of background on the developments relating to sexual minorities in Hong Kong.
Great. Well, on the rights of sexual minorities in Hong Kong, I think I would begin by saying that a lot of progress has been made over the past decade. The William Leung case, and again, I see Billy in the audience. I mean, that was the Court of Appeal judgment came down in 2005, exactly 10 years ago. And criminal law provisions specifically targeting same-sex sexual behavior were held unconstitutional. In Hong Kong today, both direct and indirect discrimination by the government would violate the equality provisions in the Basic Law and Bill of Rights. And in the Yao Yuk Lung case, the Court of Final Appeal said that, like in Hong Kong, like in many other jurisdictions, dignity is the concept that underpins the equality jurisprudence in Hong Kong. But having said all of that, I mean, there are still a number of challenges in different areas of law. And today I'd highlight just three of them, just to set the context for discussion. Freedom of speech, discrimination, marriage. And I will start with freedom of speech because I know that that's the topic of your talk this evening. And the most recent manifestation of that question in Hong Kong, and I don't know whether you've had a chance to talk about this over lunch, is the Raymond Chan incident, right? Raymond Chan being an openly gay legislator, the only openly gay legislator in Hong Kong. He was taking the MTR, the subway in Hong Kong, and there were these two women who kind of hurled homophobic verbal abuse at him. And just to give you a sense of what was said, I've translated some of the more colorful expressions. So they were saying things like, you dickless man, you don't deserve to have a penis, you should bend over, you bastard, right? And what Raymond did was he captured all this on his mobile phone and put the clip up on YouTube, and it went viral. And since then, there have been a lot of people who have kind of condemned what these women did, but at the same time, there have been voices saying that what they said is protected by freedom of speech. They should be able to say what they want because of freedom of speech. And in the context of sexual orientation, there is no law prescribing hate speech in Hong Kong. And I think one of the things that's interesting about this incident is the conflation between the political and the sexual, right? That these women explicitly said, because Raymond Chan is a public figure, right, because he's a politician, and these women, they're taxpayers, they should be able to criticize him however they want, and his sexuality is fair game in the criticism. Discrimination, there's an ongoing debate in Hong Kong about whether Hong Kong should legislate to prescribe discrimination based on sexual orientation in the private sector. And my colleague Kelly and I put together a conference a couple of years ago just to kind of give a forum to the debates, for and against legislating. And there were two kind of counter arguments to legislating that came to the forefront fairly prominently, I thought. One was the classic kind of liberty argument, right? That if I am an employer or a shop owner and I'm uncomfortable with homosexuality, I should have the freedom, right, not to employ a homosexual person. And the other counter-argument was, of course, the freedom of religion argument, right? That if I'm an employer and I'm because of my religious faith, I think homosexuality is a sin, I should not be forced to employ a homosexual person. That would be a limit to my freedom of religion. And the third issue is marriage, and I think the same-sex marriage debate takes quite an interesting turn in Hong Kong. And the most recent case is the QT case, and the arguments were heard in the court of first instance last month. And in that case, there was a lesbian couple who were in a civil union in their home country. One person comes to Hong Kong to work. The question is, what is the status of her partner? When her partner comes, does the partner come on a dependent visa, on a spousal visa, or will she have to come on a tourist visa and therefore renew it once every couple of months? And of course, on the question of visa status turns a whole bunch of issues, like whether this person would be able to work in Hong Kong, et cetera, et cetera. So that's just a quick survey, and I hope I've said enough to kind of set the context of the discussion. I'm sure a lot of these issues have come up in the context of the work of the Australian Human Rights Commission, right? The scope of freedom of speech, the balance between freedom of religion and the rights of sexual minorities, the debate over same-sex marriage, and I'll leave it there, and I invite Professor Triggs to share her thoughts with us.
Well, good afternoon. Thank you both very much, and thank you very much for the invitation to speak. It's such a pleasure, and in our discussions this morning and hearing what you both have to say, I've already learned a great deal about how things are operating in Hong Kong and how the laws work, and in a way it underscores for me why it's so important that we talk to each other across the region to understand how differently our laws work, although we come from very much the same legal jurisprudential background. We deal with these questions in quite different ways, and I find it absolutely fascinating. And in the course of preparing for the lecture this evening, one of the things that's interested me so much is that by examining our constitutions or our legislative provisions, or even institutions like human rights bodies, the paper research doesn't really give you a very accurate view of what's actually happening. And we have to learn much more about what the role of the courts is going to be, how human rights and anti-discrimination bodies actually work, and most importantly, what is the cultural environment within which these questions are being discussed. So I think it would be very valuable if Asian nations generally were able, through our scholars and through our students and those working in the field, were able to have more of these kinds of opportunities to talk about our different approaches. But perhaps if I may, I'll tell you a little bit about where Australia stands in this context of human rights compliance, but particularly emphasising the minority group, if you want to use that phrase, of Australia's First Nations peoples, the Aboriginal and Torres Strait Islanders. Although perhaps before I do that, I might just pick up on your point about mobile phones. We have to work, as we've discussed earlier today, very much from the basis of evidence. Where's the evidence for the complaints and the abuse in the society in which you live? And we try to underpin all of our work at the Australian Human Rights Commission on evidence. But one of the most powerful forms of evidence has proved to be mobile phones and videos, and whether it's homophobic abuse or racial abuse or political abuse. Young Australians, particularly, simply get out their mobile phones and they copy it and they video it. And you might have several different versions of the same event. And that has meant that the wider Australian public now believes what we have been talking about for decades at the Australian Human Rights Commission. So you could produce an academic paper with the evidence, you can have done your quality research, but it's not accessible to the wider public. But when you get something like social media and visual videos of a gross breach of what most would see as core principles of human rights, you start to get some traction in building up a political support for what we're trying to do. So I think that's been a very interesting development, particularly over the last few years. And one story that I loved in particular was one of these abuse cases on a train in Melbourne a year or so ago, and a woman, and this is often the case, the woman was probably mentally ill and on drugs or had failed to take the proper dose, but nonetheless was roundly abusing a young man, I think from the Sudan, from Ethiopia, or Ethiopia, and she was vitriolic in her abuse of him on racial grounds. But what you saw on the mobile phone was the body language of people in the train, because they physically got up and they moved towards the young man in a gesture of support. And as the train doors opened, the young man, still the victim, being abused, people on the train leant across and shook his hand. Oh, I don't know what they said, but shook his hand and got off the train. But that visual image of the support from a community that reject that kind of abuse was very, very powerful indeed. And it's relevant to something I'll be talking about tonight, which is the Australian community rejection of attempts by the new government to repeal our abuse and race hatred laws. But I won't queer my pitch for tonight, so I'll save that one. But to come back to what I know you're really all interested in today, which is minority groups in a contemporary democracy, how we protect those rights. And I am reminded, of course, as an old public international lawyer, that much of contemporary human rights law arose out of the peace treaties in the 19th century to protect minority groups. Those were the concerns that on victory you would have a majoritarian approach that would be an abuse of power, and you would fail to protect minority groups. But minority groups have perhaps not been the major focus of Australian human rights law. And if I may put this in context, Australia is genuinely exceptionalist in the way in which we go about human rights protection. And it's an extraordinary story, and one that I had not really fully understood until I took this position as President of the Human Rights Commission. First of all, we have a constitution that is primarily concerned with the respective rights of states and territories and the Commonwealth Government. It is not an inspiring document. You don't read it to get a sense of the principles of the UN or the principles of peace and human rights as you do in other constitutions. This is a very technical constitution. It's designed to deal with trade and protect the interests of what were the colonies. So in our constitution, we have very few protections for human rights. There is a right to freedom of religion, but that was designed exclusively to stop any religion being the established religion. That was the idea. It wasn't to protect people's individual rights to have a religious view, but it was to protect against any kind of established religion. But that's there. There's a right to vote. There's a right to be compensated if the government takes your property. But that is it at the constitutional level. There's nothing else in Australia's constitution except what the High Court of Australia has done is to imply a right of political communication. In other words, if you have a representative democracy, says the High Court, it's implicit that everybody has a right to communicate at a political level. Now, that's not the same as a right to freedom of speech, but it is, it's a step in the direction, but that's all that protects. Australia's been a very major player in the international environment in developing international human rights law. I think the phrase we love to use about ourselves is we punch above our weight in terms of negotiating and ratifying the major international human rights treaties. And I think there's hardly any that we haven't ultimately ratified, a couple of exceptions, OPCAT protocol being one of them. But the curious phenomenon is that we have not implemented those international treaties in our domestic law, with one or two exceptions I'll mention in a moment. So we have no constitution, or very few constitutional provisions. We are party to the international treaties, but we've never implemented them through legislation. And as you know, in a common law system, the courts cannot apply an international treaty if they haven't been given domestic legislation. But also, and this brings me back to the Asian region, of course there is no regional human rights treaty or commission or court to build a regional jurisprudence or understanding of human rights. Whereas in every other region of the world, those provisions, those institutional opportunities exist. In Africa, Latin America, North America, the whole of Europe, and now in the Arab nations. So we are exceptionalist in the region, and Australia is pretty much unique in that we do not have any charter or Bill of Rights provisions or legislative provisions that protect basic human rights. Now, there are some exceptions. And the key exception was, in fact, the Race Discrimination Convention that we brought into effect in Australia in the Race Discrimination Act. And that is probably as close to a Bill of Rights that Australia has. It's been generously interpreted, and it has been effective in being accepted by the Australian public. The Australian public wants that Race Discrimination Act, primarily because we are a nation of migrants. Almost all Australians are migrants themselves, or they're the children of migrants or grandparents who are migrants. So Australians understand that we need the protection of the Race Discrimination Act, which mirrors the convention itself. So that's one major piece of legislation which has been terribly important. The second is CEDAW, the Sex Discrimination Commission, which now has an amendment introduced only a couple of years ago to prohibit discrimination on the grounds of sexual orientation. And that, again, comes back to my point about cultural norms. The Australian public rejects homophobic behaviour. And that, while initially the religious groups and others more conservative in the community were very doubtful about Australia protecting LGBTI rights, the public over the last decade has come on board. The government was very slow to, but finally amended the Sex Discrimination Act, and that this is now a core part of Australian law, and I think supported by the overwhelming majority of Australians. The third was an interesting one, and that is the Disability Convention. Australia was one of the first countries in the world to have a disability domestic piece of legislation before the convention came into effect, but was then instrumental in negotiating an international convention, and those two marry quite well together. And disability, again, is something that attracts core support within the Australian community. And then we have the Age Discrimination Act, which does not reflect, there's no International Convention on Age Discrimination, although our Age Discrimination Commissioner, Susan Ryan, a former member of the Labor Party Cabinet, first woman to be appointed to a Labor Cabinet, is now attempting to get support for a convention on discrimination on the grounds of age. And very, very interestingly, where is the support coming for that convention? The Asian region. Very interesting. The Filipinos, the Indonesians, the Malaysians, the Chinese support it. Much more difficult to get support in Europe and North America because they feel that they've got enough law, they don't need any more. So we have a little bit of a difference, but again, I think it's an area where we can work well together. Now, that brings us right down to how do we support human rights in Australia? Because we've got so little legislation. The International Covenant on Civil and Political Rights doesn't apply. The Convention on the Rights of the Child doesn't have domestic implementing legislation. How do we actually achieve it? Well, we achieve it in part because of the common law principles broadly described as the principle of legality. And that is that Parliament is presumed to have legislated in a way that's consistent with international law and consistent with common law principles of legality, which are of fairness, judicial review, no arbitrary decisions, and so on. The greatest difficulty in Australia is that those presumptions, those common law presumptions, apply only if the relevant legislation is unclear. So if Parliament has passed legislation that is clear, the courts can do nothing about it. So given our legislation, for example, on migration law, that is clear, it's crystal clear what the government wants, what Parliament wants. There's nothing the courts can do to override it. In rare instances, the Malaysia solution case, if you're familiar with it, it's possible for the High Court to say that the refoulement of asylum seekers to Malaysia or risk refoulement elsewhere was illegal, but the moment that became clear to the High Court, the government returned to Parliament, amended the relevant provision, and we're back to the legislation again. So the common law principles of legality, of compliance with international law, can be cut out or avoided by clear legislation, and that's pretty much what's happened in Australia. Well, that brings me then to the question that we're really here to talk about, which is minority groups. As I said, in Australia, everybody's a migrant, except our First Nations peoples, the Aboriginal and Torres Strait Islanders. So Australians are primarily interested not in minority groups of whether you're Chinese or Malay or Indian or German or American. They're interested in equality of all races because we are so diverse. It's a genuine multicultural society and everybody seeks equality. Now, we do have discrimination, and we see that in the 21,000 complaints we receive a year at the Australian Human Rights Commission. But we do not have provisions which specifically protect any particular minority. And that is proving now to be a significant problem for Australia's Aboriginal and Torres Strait Islanders, because they are about 3% of the Australian population, but they suffer human rights breaches at a ratio grossly disproportionate to the rest of the Australian population. So that, for example, the prison population, depending on areas, but the prison population is between 20 and 30 or 40% higher amongst the Indigenous community than it is for the whole of the rest of the Australian community. And we have a program called Close the Gap, which is where the statistical evidence is very clear that Indigenous Australians are, to various degrees, likely to die as children, to be imprisoned, to have poor education, to be without a job, to be homeless, to be sick, to have diabetes and various other medical problems. All are exponentially much greater for Aboriginal and Torres Strait Islanders than they are for any other group in the population. So Australia has accepted the Declaration on the Rights of Indigenous Peoples, but that is very, very poorly understood by the Australian community. I think probably most have never heard of it, and the government tends to ignore it because it's a declaration and it doesn't have the status of binding treaty. But of course, even if it were to have status as a binding treaty, it wouldn't have been implemented in Australian law. So we have a very significant problem in Australia in trying to ensure that Aboriginal and Torres Strait Islanders are properly protected. And they have been protected effectively, many would say, through the Race Discrimination Act. And that is seen by them and by other groups within the community as the most important protected piece of legislation. But very sadly, the Australian government suspended the Race Discrimination Act for the purposes of what's known as the Northern Territory Intervention. And now this is an issue that you may have very different views about, but there was a very powerful report produced by credible bodies showing that Aboriginal children, and girls in particular, were being sexually abused in Aboriginal communities, particularly in the Northern Territory, at a level that no community could tolerate. very, very high rates of sexual abuse. And it was called Little Children as Sacred. And the Australian public responded very quickly to this report and said, we cannot tolerate young Aboriginal children being sexually abused. In other words, somehow or another, the line had been passed, and the Australian government said, we will act for the first time in this way. And over a weekend, and without consulting with Aboriginal and Torres Strait Islanders, they passed or drafted a piece of legislation called the Northern Territory Intervention Act, which allowed the Commonwealth to move in with the Army and with medicos and various government officials to move into all the Indigenous communities in the Northern Territory, and in some instances to take the children away. Now, those of you with some knowledge of Australia will know that we've already been through an horrific period of the stolen children generation, and our Prime Minister, Kevin Rudd, has apologised for that. But now we have another phenomenon going in to save these children from sexual abuse. Now, what actually happened was that the Northern Territory intervention legislation was a mask or a vehicle for going into the territory and undertaking all sorts of social programs that almost typically did not include sexual abuse of children, but nonetheless it was the vehicle for suspending the Race Discrimination Act. The Australian public supported this for some time, but then everybody became deeply concerned at the suspension of the RDA, and it's now been reinstated with some precautions. But there are many, many other examples of special laws being introduced in Australia for the Indigenous community, but which have sort of gone rather badly wrong. One of them concerns liquor laws, that if I am picked up by the police in my car with a bottle of gin, nothing will be said or done about it. But if an Aboriginal woman, as occurred in one case in Queensland, was picked up with a bottle of gin in a car, she can be prosecuted and given a jail sentence of 2 years. Now, that is clearly racially discriminatory. But the question is, can it be justified under the Race Discrimination Act, under the special measures provisions? And the High Court of Australia has ruled that it can be valid as a special measure. So, without going into any more detail about this, it gives you something of a flavour of how Australia is dealing with minority issues. We wouldn't consider LGBTI rights as being particularly a minority question. We now see that as an integrated Australian phenomenon, a one across the entire community, and the entire community supports it. And we wouldn't see Chinese or Indian or Europeans as being minority groups. We just don't view it that way. We see them as entitled to equality of rights, except with regard to Aboriginal and Torres Strait Islanders, where the statistical evidence is so damaging. What can an Australian Human Rights Commission do? We are an independent A-status body, and for those of you who've been following the Australian news, you'll know we're in a lot of trouble at the moment, in particular me. We do find ourselves running up against the government on some issues. And perhaps I can rush to say that 90% of what we do is supported across party lines. So we have 5 commissioners: children, race, Aboriginal, Torres Strait Islanders, age, disability, and sex. And most of the work done by those commissioners, they're independent statutory appointments, as am I as president. They work within their portfolios, and they do so almost invariably with the full support of both major parties. And it works well, it's successful, and they're respected. But in some areas, unfortunately the ones that I take on as president, tend to be the ones where the government profoundly disagrees with my view. And I've picked up in particular asylum seeker rights, concerns about arbitrary detention, particularly of Aboriginal and Torres Strait Islanders, who are imprisoned much more frequently, as I've said before. They're also detained arbitrarily, in my view, with cognitive disabilities. They're unfit to plead, and they end up in criminal facilities for decades without proper treatment and without examining other alternatives. So unfortunately, I do tend to have taken up the issues that are most controversial, and also as president, I'm solely responsible for the 21,000 complaints we get a year. So I make the decision, I sign off on them and report to Parliament. So inevitably, much of the criticism comes back to me. Sadly, on asylum seeker policy, both major parties disagree with me. So I'm bipartisan regardless of the issue, but unfortunately means that I cannot get the support of opposition parties who also support offshore processing and the mandatory indefinite detention of children. So on issues where I believe I'm rock solid on the law, it's still very difficult to get the political support of the major parties, and that explains really why it's been very difficult for me as President and members of the Commission over the last year or so. But I would like to come back with the point that given that Australia does not have constitutional protections, we don't have a regional charter other than ASEAN, which I think you know is it's a start, but it's not really there, and we don't have many legislative protections for human rights. I think in our case, an independent statutory body like the Australian Human Rights Commission is a very, very valuable tool to be able to hold governments to account in a way that's protected by that statutory independence. So while it's an awkward position to be in, I think it's one that I need to use very confidently because there are so few other avenues for seeking solutions. I think our courts, like yours here in Singapore, have a very high calibre judiciary. The quality of the work they do is very high, but they are so constrained by the precise terms of the legislation, the sovereignty of Parliament, if you like, that there's very little they can do. And one of the matters that I'm speaking out on a great deal now is the difficulty in a modern democracy where you have the major parties of Parliament working with the government to reduce core human rights freedoms. And that is particularly troublesome when you're dealing with minority groups, because Parliament, I believe, in a modern democracy, should understand that its role is to do more than simply vote along party lines, but to be sure that Parliament protects those rights that parliaments were initially created for in the 17th century. They should be standing up for the minority rights to prevent an abuse by the executive and by the majority. And I think that's a challenge for the 21st century. So I'm afraid I imagine I've spoken for far too long, but I think that list gives you a setting for how and why human rights issues in Australia have become so problematic. But I'd like to finish by saying that I would like to see much more discussion in the region to work out how we deal with issues like race hatred, sexual orientation issues, and minority issues. So thank you very much.
Thank you so much, Professor Triggs, for sharing what's been happening in Australia. And I think that you really touched on some of the core themes and things that we've been witnessing here in Hong Kong. Our parliament, for example, is one which has a system whereby the representation isn't sort of direct, one of direct democracy. We have two sort of constituencies. One is voted into the geographical constituencies, and the other is really professional sector-based representation. And for a long time, we had a system whereby some people, particularly the professional classes, had 2 votes or 3 or 4, depending on where they stood, and then others just had 1. But now we've sort of rectified that, and we've got a supermajority seat, a super seat in LegCo, where everybody gets 2 votes, and those who don't belong to a functional constituency can just vote for the super seats instead. But that basically divide in LegCo has really led to a great deal of blocking that happens when issues concerning minorities end up in LegCo. But what is also interesting is, even where public opinion polls, for example, I think in relation to sexual minorities, show that the public is starting to sort of move in the other direction and would be happy to see legislation to protect them against discrimination, that's still not taken up because our system is one where the government is in charge of introducing bills into LegCo. So if they don't do it, it's very hard to have a private member sort of initiate a bill. So there is sort of resistance and difficulties there. But what I'm really particularly interested in is sort of the idea that that you touched on, which is we need to be speaking to each other a lot more. And I'm really glad we have the opportunity to do so today. And we still have time where I'd like the members of the audience to have a chance to engage with you and ask you specifically, I think, a lot of the budding issues on their minds. But I wanted to say that we have been looking regionally, I think, to other sort of trailblazers in certain areas. And Taiwan sort of shines as an example that's made much progress on, for example, LGBT rights. So it's interesting to sort of learn from them, particularly since they're also a Chinese community. So people are starting to look outside and see, well, what are our possibilities exactly? So to that end, I think it's very important to keep the dialogue open. And I'd like to invite any of you who would like to ask Professor Triggs a question on the area of work that you're doing. I'd ask you to please introduce yourself and keep your question brief so that we can have as much discussion as possible. We have about 15 minutes, so we'll just go from there. Peter.
Hello. Yeah. Thanks very much. It's a pleasure to hear you, Professor Triggs, for two reasons. Firstly, because I work at the Equal Opportunities Commission here in Hong Kong, but I'm actually an Australian, and my parents immigrated from Hong Kong to Australia, and I'm a human rights lawyer who also worked in Australia. But in terms of the issues, there's a few things that we're interested in, because at the moment at the EOC, we've got two major projects. One of them I'm sure Ferret can talk about, which is the study about introducing sexual orientation, gender identity, discrimination laws in Hong Kong. That's one major area of work. And the area of work that I'm leading on is reviewing all of our existing laws, including race, discrimination, disability, sex, and so on. And well, the questions I have are, well, two, just to keep it brief, because I'm sure many others have questions, is in relation to the federal legislation in terms of sexual orientation and gender identity. I know they were introduced, I think it was in 2013 in Australia, and I know that's not long in terms of seeing how they've been enacted and the experience of that. But my general question is how they've been received. Have you had many complaints? Do you think it's working effectively? And especially, what has been the reaction of religious communities in Australia? Because in Hong Kong, generally speaking, it's the religious groups, particularly Christian religious groups, that have the strongest opposition to introducing such legislation as it is the case internationally. So that's the first question. And the second question is, in relation to racial vilification, I understand that the government is considering amending those provisions or repealing them. I'm not really quite sure because I haven't been following closely. And I'm just interested to hear what your views are on that, because we are also reviewing our laws at the moment in relation to vilification and, for example, the possibility of extending them to sexual orientation, gender identity, and so on.
Well, thank you very much. And nice to meet you, and to know you've got such an Australian Hong Kong background. To deal with the last question first, the Australian government, and I will be talking about this in rather more detail tonight, but the Australian government came to power and said that they would repeal the racial vilification laws or race abuse laws. And to cut a very long story short, the Australian public rose up and defended it and said, no, it's important to keep those laws in place. We want them in place. To go back to the incident I told you of the Ethiopian on the train, Australians see the need for laws that prevent abuse on racial, national origin, ethnic and religious grounds as important. So the government had to do a complete about-face and announce that they would not proceed with the reform. And I think the lesson to be learned from that is that, again, to come back to the point I've made, if the public absorbs as a matter of cultural normative behaviour these core human rights principles, then it's very hard for the government to wind them back. And the government failed signally on that issue. Now, the former government had introduced the new laws on sexual orientation, and I and many of us at the Commission were very cautious about this because we weren't sure that there was community support for LGBTI rights at a core level. But we were wrong. The Australian public's just completely embraced them. And overwhelmingly, Australians are now urging the government to bring in marriage equality. So, although, as you say, they've only been in for a couple of years, it's difficult to give a proper evidence-based view as to how it's working. We do get complaints at the Commission. Of course, it's now part of our complaints process, but we get very, very few. I think Australians have really internalised the idea that you cannot discriminate on the grounds of LGBTI rights. Now, perhaps one qualifying factor there is that Australians are not really a religious people, so that the religious groups do not have the same lobbying power that they might have in a community, for example, in the United States or in Europe. They don't have as much traction. And there's quite a strong feeling, particularly, that if religious groups receive public funding, for example, running aged care facilities, they cannot refuse to have a same-sex couple use those facilities. So we now have legislation to that effect. There may be some pushback against that. There are some, I think, many people take examples from the United States, when you can always find the most extreme case somewhere in America. But there's one where somebody refused to make a wedding cake for a same-sex couple. I think it's probably a much discussed decision. Well, that's not happened in Australia, but I mean, maybe it will, it's possible. But I think we tend to get hoist on these highly hypothetical or very rare problems, when in reality, when we checked at the Australian Human Rights Commission with the Catholic bishops, with the Uniting Church, with the Baptist Church, with the Muslim community, we were told that for practical purposes they would not discriminate. And particularly the Christian religion said, Christ casts a wide net. We do not discriminate on that basis. Now, there are undeniably exceptions, and if there are, they'll come to us, we'll handle the complaint, and if necessary, they'll go to court. But that's the law, and we think it's working quite well.
Professor Triggs. Hi, my name is Fazana Aslam. I'm part of CCPL, and also I chair Justice Centre Hong Kong. It was interesting for me to hear you discuss the 4 areas in Australia where there is legislation, so race, age, LGBT and sex, I think before. But in each one you emphasised how the public were very supportive. And my question to you, and I'm interested to hear sort of Peter's view on this, I know, because the EOC here very much want to get public support and go out to sort of consult with the public before taking the lead on legislation. And, you know, how important is that? Because I guess I come from the perspective, from a rights perspective, that, you know, government has to take the lead, even if the majority of the public have these discriminatory views. Surely we can legislate first and expect people to follow, or is that the wrong way of looking at it?
No, well, I think the central point is that education is absolutely vital. And it really, I see it as the most important thing that we do at the Australian Human Rights Commission, and we're investing more and more money in education. The curriculum for all Australia does include human rights education. But one of the difficulties for teachers is that they are not trained lawyers, they're not human rights lawyers, and they don't know quite what they're doing, and they're very busy people, teachers, there's a lot of demand. So what we're doing now is creating modules that fit the curriculum requirements for particular years across the Australian curriculum, so that a teacher can simply come onto our website and download a teaching module to teach a particular issue. It might be the rights of a child or a disability rights or whatever it is. They can download it and the materials are all there. We're also investing quite a lot of money in interactive videos and teaching materials to get them out through the teaching federations to teachers out into the general community. And they're all on our website if anybody ever wants to use them. Now, to come to your question, I think it's a fascinating one. Yes, indeed, I do think that government should lead. In fact, I've found in this position in the last 3 years, I now have an even stronger view of the importance of leadership, particularly from government. But government leadership is absolutely vital, and if you don't have it, it's virtually impossible to achieve cultural change, because you will have too big a group in the community that will take that as the easy road out. And that's indeed been underpinning my problem with asylum seeker rights, because if you have leadership that says asylum seekers are illegals and intimates that they're probably terrorists as well, then it's extremely difficult to get change. But if you have leadership, people start coming out and saying, we cannot tolerate discrimination on the grounds of sexual orientation, then you get a turnaround. So our role is educative, but I deeply believe in working as well as we can with our leaders. If I can just give you an example, just before I came here, I had a meeting with a very conservative politician from Bundaberg in Queensland, if you know where that is. It's a sugar-growing country. It's rum. They create the rum. Now, you couldn't get a more conservative part of the Australian political community, but this particular national politician wanted to see me. I was a bit surprised, went along to see him. What he's interested in is seasonal labour and the very poor treatment that they're receiving as seasonal labour. They're typically migrants, or they've come to Australia on visas and overstayed their visas, so they're vulnerable. And this man has taken up this issue. He's concerned that they are being abused, they're not being paid the proper salaries, their conditions are appalling, they're like an underclass in Australia, and there he is saying we have got to change attitudes and we've got to protect seasonal workers. Now, when you get that kind of leadership, then we can work very well with that leader. We're going to do all sorts of things, I hope, with him over the next coming months, and hopefully encourage Australia to sign the Migrant Workers Convention, which I think we should do in the region, because so much of this movement is across our own region. The biggest numbers are. So I think it's exciting. You can do it, and you can cut across the political groupings if you can work with those political leaders, but they're absolutely vital.
Kelly Loper, I'm a member of the law faculty here at Hong Kong U. This is sort of a follow-up question. You mentioned your very controversial work on the detention of child asylum seekers, and you mentioned that you don't have any support from any of the major political parties. But I'm wondering what the public reaction has been, and whether you could see, I mean, you talked about the importance of leadership of the government and influencing public opinion, but is this a case where it could be the other way around, where public opinion might actually influence the government's decisions on refugee policy?
Well, thank you. And I think, although I have to be very careful in responding to that question, I do believe that the thousands of children that have been released over the last, or to be absolutely precise, the 1,100 children that have been released in the last few months, that does owe something to the public acceptance of our report. So although the government has rejected the report, the Labour Party hasn't positively rejected it, they've just not said anything. They don't want to be wedged on the issue. But basically, what is happening is that the tide is turning. The public support for our report has been huge. But also, Australians are migrants. And when you talk to certain groups, they came as refugees to Australia. The Vietnamese community, Sri Lankans, but of course also the Jewish community after the end of the Second World War. Many, many thousands, tens of thousands, came to Australia, and while they were refugees, they usually came without papers. They used people smugglers too. And they've been coming out and saying, well, just a minute, what is Australia based on? And it's actually based on many illegal immigrants who ultimately got proper status and were respected. So what's happening is we find that people all over Australia are supporting our view. And I think the government continues its policies at its peril, because ordinary Australians are saying this is mean-spirited, and that great Australian phrase, it's not a fair go. You know, Australians don't know much about human rights law, and we haven't got a culture of constitutions, but they do know a fair go when they see it or when they don't see it. And so I do believe that we're having an impact. The public response has been wonderful. And I mentioned to you, if I may say so over at lunch, that 30,000 people are now adrift in the Australian community with no claims. Their claims to refugee status are being ignored. But what's happened is that the Tamil community, the Pakistani community, they've all opened their arms and drawn in these people to support them, make sure the children are properly enrolled in schools, they've got medical care, they're being looked after and engaged in the community. So I think ultimately it comes back to community endorsement of a humane approach to this vast problem of the movement of peoples. 60 million people were estimated by the Secretary-General as displaced or as refugees last year, and it's getting worse. So we have to have a global and regional approach to this, and obviously one that we can all live with as a humane response. Thank you.
We have time for just one last question. I think Phyllis has had her hand up for a couple of times.
Thank you, CCPL, for organizing this seminar, and I would like to commend Professor Triggs' work, especially under the Abbott's government. I'm Phyllis from Unison. We are a rights-based organization fighting for equal opportunities for ethnic minorities in Hong Kong. Ethnic minorities here, I think you may have got some briefing during your lunch. It's not the Aboriginals or, yeah. So they are non-Chinese people. I have two questions. The first one is, how effective was the commission, your commission, to influence implementing the international treaties into local legislation? And the second one is, as Puja mentioned in the beginning, we don't have a Human Rights Commission in Hong Kong, and I think the Equal Opportunities Commission is the closest thing. But do you think it is effective as a commission to be a statutory, regulatory, and education body all in one?
With regard to your first question, Australia has been very poor indeed in implementing the treaties to which we're party into domestic law. We hardly ever do it. So that is why we have a huge gap between our international obligations and domestic law. And that's pretty well exceptional and unique, certainly, amongst common law countries. So Australia is very, very unusual in failing to give effect to those laws. With regard to the role of a commission, I think you can put them together. A lot of the complaints that we receive, which is 30% of our work, they might be based on arbitrary detention, race discrimination, and maybe disability, all in the same. In other words, when somebody's rights are being breached, it's very often a combination of factors, and it does work quite well. I think the educational role depends in a way on us understanding what's happening at the complaints level. So when I talk about the 21,000 complaints, I can say we get very few on LGBTI rights, for example, and I can be accurate because we're really at the coalface. We really see what ordinary Australians are concerned about, and we can translate that into policy. So I think the combination of roles works very well indeed. But of course, to be effective, you must be genuinely independent. And that varies from government to government. But of course, the greatest risk to our independence is in fact the budget. So whichever way you come at it, even though we would be confident that what we're doing is legally consistent with our statute and that we are acting independently, we are still enormously vulnerable because each year the government determines our budget, and that budget sadly dramatically declines. And we've just had a 30% cut effectively. So these are the realities, and you get a change of government and suddenly the budget goes up again. So that's unfortunately the reality. But I do believe that the concept of an independent statutory body is a very important one, and there are 110 national human rights bodies in the world now, and they've just been given as a group the right to intervene in matters in the General Assembly. So they're becoming a more effective institutional body that links government on the one hand and civil society on the other. And I see them, I've become a very strong advocate for national human rights bodies. And as I was saying at lunchtime, I've recently been in China, talking to China about establishing a national human rights body. I don't think they were very convinced, but nonetheless, at least they're asking the question and considering it. And I think it would give China a very, very powerful voice in the region and internationally were they to adopt one. But we'll see. Thank you very much for your question.
Right. I'd like to round off by saying thank you to Professor Triggs for sharing with us the Australian experience, but more particularly, I think, leaving us with a few things to think about in terms of how we chart our journeys forward in advocating for the different groups that we work with. And I think essentially the message really has to be that education and community awareness has an indispensable role to play, especially in the context of Hong Kong, where we have a reluctant government, and we do have the sort of flawed machinery that we do, whichever way you look at it, that we have to work within those constraints, unfortunately. But we can still, I think, strive to improve the situation despite these constraints. A recent study I completed for the Hong Kong Committee for UNICEF shows that children in particular are grossly unaware of their own human rights. Teachers are afraid of teaching human rights and fear loss of authority. An overwhelming majority of them weren't aware of equality-related provisions in Hong Kong, weren't aware of our commitments internationally. So I think there's a great deal of work to be done, and I think the Australian Human Rights Commission's work on putting up these materials for teachers to have access to as resources to draw on is an excellent start, and I think it's something that we need to be thinking about here, given that we've heard about how wrong our own textbooks are going in Hong Kong, which are used to educate our children, where you see very stereotypical and discriminatory examples peppered across those textbooks. So I think that's one thing that we definitely need to push for and work towards. And I think the other important thing, of course, is the importance of having the public opinion on your side. And that requires a huge cultural and normative shift in how we think about people. And I think something else that Professor Triggs said earlier, which really struck me, and it's something that we've been talking about in the circles, but nobody's really sort of put any concerted effort into this, is about the labeling effect of using the term minorities, and whether that is sort of an undoing of sorts in terms of advocating for the rights of particular groups of people. So I think there's a great deal for us to sort of work on and learn from, and I hope Professor Triggs has also helped inspire colleagues at the Equal Opportunities Commission in terms of what there is that can be done, even though you have the mandate that you all do and the great work that you do there, that there's still room where you can work together with all of us and the public to move things forward. With that, I'd like to invite you, if you can, to attend Professor Triggs' lecture this evening on free speech and the Charlie Hebdo controversy. Again, I'd like to extend a very warm thank you to Professor Triggs on behalf of all of you for joining us at the faculty today. Thank you so much.